My name is Jeff Keohane with the law firm Schwabe, Williamson, Wyatt. I work in California, also licensed in Washington, and so this presentation is going to be on state tribal consultation and focusing on California and Washington. For the attorneys, don't forget to come up to the front and sign in to get your CLE credits. Also, if you want a copy of the PowerPoint presentation, there's a sign-in sheet, or you can just leave your business card. I don't know why I blanked out on that. So the first thing I'm going to be talking about three different types of consultation. First, we'll talk about federal consultation to lay the basis for what we're talking about. And then I'll switch over to California and then Washington State. So, and actually I forgot, as a lot of people do, about the international context. So I'll be talking about that as well, very briefly. But first, in terms of consultation best practices, since this is a tribal audience, this isn't quite as useful. But when I talk to non-tribal entities, or I tend to make sure they understand that from my point of view, at least, consultation needs to be early in the process before decisions are made, difficult to change. It has to be meaningful. There has to be a meaningful opportunity for the tribe to contribute and to affect the outcome. And that the consultation should not be blended in with public comment. Instead, it should be individualized to the tribe, or at least to tribes. And the confidentiality for vulnerable tribal cultural resources needs to be protected as well. Sometimes that can be difficult with public records laws, with FOIA particularly is an issue. But there are ways to cope with that. In thinking about about what consultation is, I tend to think of it in terms of first the scope of the consultation. So the agency's discretion, what it can actually, is the action it's doing, does it have discretion over how to accomplish it, or has it been directed by the state legislature or Congress to do a specific action and doesn't have a lot of discretion? Does it include federally recognized or non-recognized tribes? Generally, consultation at the federal level and at most state levels is limited to federally recognized tribes. In California, it's not so limited. Non-recognized tribes are also included in a lot of the consultation obligations. The question also of tribal matters. What is the scope? What is the trigger for the consultation? So, for instance, with the federal executive order on consultation, talks about tribal implications and isn't very clear on what that is. And then meaningful impact. I think that's pretty self-explanatory. Timing, again, early, and outreach to tribal government, or is it passive? A lot of state policies are simply passive, waiting for tribes to come to the state to seek consultation. And frankly, a lot of federal consultation works that way as well. And then, to repeat, what is the authority of the consulting body to keep things confidential? So is there an exemption from the Public Records Act, for instance, in California? Is there the ability to fit it within one of the narrow exceptions to FOIA? Things like that. Now, in the Declaration on the Rights of Indigenous Peoples, consultation plays a major role also in the Convention on Biodiversity. And This is the origin from Professor Miller sent me his consultation article and said, you should look at this. So I did, and this is the source of his formulation. So I had said that consultation should be early, meaningful, individual, and confidential. His formulation is free, prior, and informed consent, which is from the 4 underlined words there. And so that's another way of looking at this. It's because this is the United States, we don't pay as much attention to international bodies as perhaps other countries do. But this is one of the standards by which consultation should be judged. And note the word consent. You won't find that in virtually any state or federal consultation policy. So where does consultation come from? The courts originally found a trust, that part of the trust responsibility, importing one of the principles from private common law trusts. The trustee must consult with the beneficiary of the trust and keep them informed. The trustee is still in charge, but they have to consult. In the case of the United States, the courts found that there was a duty to consult. There's a specific duty before taking actions that affect trust resources, timber, hunting, fishing rights, water, and land. So, and that's found expression too in eventually in BIA regulations that require tribal consent for certain leasing and other decisions. There's a general trust responsibility to consult about other things, and that's where regulatory actions fall. At least the way that consultation has developed over the last 20 some odd years in the United States. And there's a sort of general consultation duty, moral duty to consult with tribes that springs out of the trust responsibility, and then that can be narrowed or expanded by statutes such as NEPA, other environmental statutes, and particularly the National Historic Preservation Act has very strong consultation requirements in it. And so those are additive or maybe subtracting from the general moral duty to consult. So Section 106 of the NHPA, which I saw a few of you nodding about, is the strongest requirement to consult. It's not worded in the strongest way, but the other requirements for consultation that are worded more strongly tend to be policies rather than actual statutes or regulations. So in this case, federal agencies whose actions or federal undertakings may affect historic properties on Indian reservations and tribal trust lands must consult with tribes. Off of reservations must also consult with tribes on matters that are of areas that are of cultural or religious significance to the tribe. So probably the broadest and strongest statement of consultation duties for the federal government. I've thrown in ARPA, the Archaeological Resources Protection Act, because it is, one would think it would also be strong, but instead it applies to archaeological historic resources on public lands, and the only mandatory duty is in the regulations, which say that the agency that is granting if the Department of the Interior is granting a permit that's going to lead to damage or destruction of a resource, they must inform the tribe. However, they only should consult in case of harm or destruction. I believe these days that they actually do consult but there isn't, the regulations still don't require it. And then there's an interesting case of the Elementary and Secondary Education Act, which flows down to local school districts. So rather than a consultation requirement upon the federal government itself, this is one that flows with the provision of Indian education funds under Title VI. So if a school district receives $40,000 or has over 50% Indian students, is required to consult with local tribes. And that's something that has been a challenge here in California, because even though there's California law on this and federal law on this, a lot of school districts have been ignoring this responsibility. So with regard to, everybody knows probably about Executive Order 13175, signed by President Clinton in 2000. It's been reaffirmed by most of the presidents since, and in fairly strong language. The latest with the Biden administration defined the trust responsibility to consult regular, meaningful, and robust consultation with Native nations, with tribal nations. This is I'm going to skip through the rest of the executive order fairly quickly, but the point here is just to point out how much consultation has gotten entrenched into federal policy making. Which it's my thesis that that's where at the federal and state level, when it becomes habit for agencies to actually consult, is when it actually happens rather than when it's mandated from above. The various sections of the executive order require the agencies to have accountable processes and so forth. In terms of my rubric of early, meaningful, and so forth, the executive order does a good job on the timing of consultation, that it should be early and meaningful. It's missing the requirement that I would like to see in there, that it be individualized in case of particular federal actions that influence particular tribes. Now, in fact, in practice, agencies, if there is one tribe involved, they generally do just consult with that one tribe, or they don't consult at all. But the fact that it's missing also means that agencies, less so these days, but we're able to go ahead and say, all right, well, our NEPA consultation takes care of this, or our NHPA consultation takes care of this, and we don't need to continue past that. Let's see. One thing is the encouragement of Indian tribes to develop their own policies. That's a significant thing that has not been effectuated much outside of the Department of the Interior. I'm going to skip over, as I said, some of the detail of the executive order. Interestingly, back in 2004, there were two Appropriations Acts passed that required that Alaska Native corporations be consulted with by federal agencies on the same basis as Indian tribes. This is, it's an interesting take on consultation. It's been done, and I think is, resulted in some good outcomes. It is a little bit off with the basis for federal consultation being the federal trust responsibility to Indian tribes rather than Alaska Native corporations. But since Alaska Native corporations do represent a lot of natives in a different way than tribes do, but do in fact represent them, it makes some significant policy sense. So The other aspect of it is that that I think is most important is that it's although the executive order could be withdrawn by any president at any time, the fact that it's now part of federal statutory law, although only recorded as a note to Section 450, the fact that it has been recognized by Congress makes it a little harder to then withdraw it, and gives it a little more higher profile, I suppose I would say. All right, so turning to state consultation, I talked about the source of the federal consultation requirement, the duty to consult arising out of the trust responsibility. For states, there hasn't been a recognized trust responsibility to tribes in most states. There is so where does it come from? And one of the questions that comes up a lot with regard to state consultation policies is it discriminatory because the states don't have the special relationship with tribes that the federal government does, recognized in cases like Morton v. Mancari, where it's a political association rather than a relationship based upon race. So the argument back is that it doesn't particularly matter. The fact that it's you're consulting with another government means that you're not violating any non-discrimination laws. I would put in there too, though, that there is this open question about California's consultation with non-recognized tribes, because non-recognized tribes may have their own government, and it may in fact eventually be recognized as a government, but at the present time it's not recognized that way. They're usually deemed unincorporated associations, or in some case nonprofits. And so consultation with them is, the basis for saying it's non-discriminatory can't be the same as with federally recognized tribes. So where does it come from? There are moral and practical considerations that show up in California and Washington states' history of consultation policies with tribes. There's the moral side of it is the fact that tribes are important representatives of large numbers of citizens of the state. There's also the practical side that they control significant jurisdictions, and particularly around Puget Sound in Washington, that are areas where it would be difficult to do planning without their cooperation. On the moral side, California has acknowledged its guilt for 50 years of warfare against Indian tribes in the 19th century, and being complicit in the boarding school travesty. And there's also, we can't forget just plain politics. In both Washington State and California, tribes are important players in state politics. There have been several of the acts that create the consultation process have been initiated by tribes, and been encouraged. The governors have been encouraged to issue their consultation policies by tribes as well, and the fact that they have that effect, that can have that effect, shows the significance of tribes as political actors now in at least those two states. So, state consultation, some of it is by legislation, as I mentioned. 4 examples, including California and Washington, Oregon, New Mexico. Most other states, however, consultation policies, to the extent they exist, tend to be by governor's executive orders, or by by administrative orders by the head of other elected offices, such as the Attorney General's office or Department of Justice, depending on the state. That tend to be where in the states that you would expect, generally in the West, but also in the Midwest and the scattering in the East. The scope of the policies range from looking at state policies that have particular impacts on tribes to just looking at state policies generally. California and Washington fit into the second category, where state policies that have effects on tribes but are not necessarily particular to tribes are also included within consultation. Also, as I mentioned earlier, there's a question about, is this for instance, I'm probably going to get the state wrong, so I won't say this, but in a large Western state, there's a consultation policy, but the result of it is basically to have a liaison in the governor's office who waits to hear from tribes. In California, we have a more active governor's office for tribal policy. And the state agencies are, at least for the last 6 or 7 years, have been developing under the governor's executive orders, have been developing policies that require them to proactively consult, unevenly, but still proactive rather than waiting to be contacted. As I said, outside of California, it's generally limited to federally recognized tribes. So let's get to California. Also, I should say, for those who are coming in and those who are taking photos of the PowerPoint, if you want, you can sign up for me to email you the PowerPoint after the presentation. Also, I should have mentioned at the beginning that if anybody has any questions along the way, please feel free to interrupt and ask them. Easier to do at the time when I'm actually talking about the thing that you're interested in than waiting till the end. So, with California, it starts with the executive orders back in 2011, or at least that's where I'm placing it. I know that arguably it could go earlier, but Governor Brown required that agencies and departments shall, and this is interesting wording, shall permit tribal governments to provide meaningful input into the development of legislation, regulations, etc. And that may affect tribal communities. And that's where the Office of the Tribal Advisor originated. Now, it's stated quite broadly. There is the troublesome word permit. That has been read out to a certain extent. But also the may affect has been read out to a certain extent, and most agencies just consult about things that they think will affect tribes. So then Governor Newsom in 2019 reaffirmed Brown's executive order, emphasized the consultation requirements, and by the time that Newsom came to office, most agencies, at least all of the large agencies that I know of, had already enacted consultation policies. Around 2016 seems to be sort of the peak. This also importance was Governor Newsom's apology for the treatment of tribes in the state by the state in the 19th century and onwards, and the establishment of the California Truth and Healing Council, which it was something of a question whether the Truth and Healing Council is consultation in the sense that I've used it in this presentation, but it obviously is, because it's the state, although it tends, the council is made up of tribal representatives. They are helping the state to receive consultation from Native peoples about how their treatment by the state and their concerns about how the state should move forward and how it should address past wrongs. And to repeat my hobby horse here, their consultation policies apply to all California tribes. So that includes not just the 110 recognized tribes, but 55 non-recognized tribes and 12 terminated unrestored tribes. So all of those entities to, obviously the federally recognized tribes have governments. The other entities have, recognizable government functions to a greater or lesser degree, depending on the tribe, and greater or lesser difficulty in consulting with them. So legislation is, while it's very important that the governor's office makes sure that that all of the agencies, which the massive agencies that we have here in California, consult with tribes. The only permanent way to make that happen is to, well, somewhat permanent anyway, is to have the legislature enact consultation requirements into law, so that it's less subject to who is in office at the time. This is a list of some of the areas of consultation. I'm not going to go through them all unless anybody has any particular questions about them. I'm going to talk mostly about SB 18, which is has to do with tribal cultural sites, cultural and sacred sites, and AB 52, which has to do with consultation under CEQA, which, for those of you who don't know, CEQA is the California Environmental Quality Act, and it applies to all major actions in the state of California by a governmental entity. So, looking out at the audience, I think most of you probably are familiar with SB 18, but it's a law passed in, I believe, 2004. It's applicable to all local governments that adopt general or specific plans or create open space designations. The process for the consultation is that the local government sends their proposed changes to their general plan or their open space designation to the Native American Heritage Commission, which then gives them a list of tribes to consult with, tribes that whose traditional lands or places are within the geographic boundaries of that are affected by the general plan, specific plan, or open space designation. The local government contacts the tribes. It ends either with an agreement or disagreement in good faith after reasonable efforts. It's not. It's somewhat enforceable, but in the end, it's the requirements are what's called directory, not mandatory, meaning that you can't go to court and invalidate a general plan because the consultation wasn't done properly or terminated early or that sort of thing. Generally, and this may be a sample bias because when a lawyer is involved, things tend to be done a little bit more by the book, maybe. Thinking about sometimes when things happen, they don't happen that way, but most of the times that I've been involved with SB 18 consultations, it's gone not smoothly, but the local government has proceeded in good faith, and even if they haven't done exactly what the tribe has wanted, they've tended to try to meet them partway and tended to take some action to protect the resource. It's damning a little bit with faint praise, but there it is. It is something. So moving on to AB 52, which is a much bigger deal. Not to diminish SB 18 and its protection of sacred sites, but within the state of California, the creation of specific and general plans and open space designations is not nearly as common as major agency actions that trigger CEQA. So, and I'm not going to go, because CEQA is such a complicated subject, I'm not going to go into it in great detail, except to say that if you're familiar with NEPA, it's like NEPA, except that it, rather than with NEPA, you have to consider the environmental effects and then may proceed regardless of the negative consequences. With CEQA, you have to, if it's feasible, you have to mitigate the environmental consequences. What AB 52 did was to insert into CEQA the requirement that any agency performing a CEQA analysis has to consult with tribes. Now, the the key element here, the key factor here is that before that happens, however, the tribe must have requested consultation first. So this violates one of my best practices, which is that the agencies reach out to the tribes. The state of California determined that that was infeasible, and that so all of the tribes were informed of their opportunity to tell state and local agencies that they had the opportunity to consult. And that was in 2015, don't remember exactly the date. And so all tribes received that information and were then, and all the tribes that I've worked with promptly sent out notices to all the federal state agencies and local agencies that were of concern to them, saying we want to consult if you do a CEQA document. So the trigger is the if there, as soon as 14 days, within those 14 days of an application being deemed complete, or a decision to undertake a project, then there has to be a formal notification to these tribes that have told the agency in advance that they want to be consulted with. There's 30 days for the tribe to get back and request consultation. Consultation must begin within 30 days and before the release of the environmental document. So that's the early and meaningful prongs, also the individual prong, just not the not the active part of it. They don't have to have sought out the tribe. The tribe has had to seek them out in the first place, but then once they have, the agency is required to consult with them. The topics of the consultation must include alternatives and mitigation significant effects, which are the core of CEQA. Like NEPA, CEQA requires the study of alternatives to the action, including a no action alternative. And if there are significant effects, requires the study of mitigation. And unlike NEPA, that, as I mentioned earlier, if that mitigation is feasible, it must be adopted and must be enforceable. So as for when how this is enforceable, unlike SB 18, like SB 18, consultation concludes either when the parties agree on mitigation measures, if there are significant effects, or a party, in this case meeting the agency generally, decides in good faith after reasonable efforts that no agreement can be reached, they can end consultation. A tribe could also do that, walk away from the table and say this is no good. There have been tribes that have done that, and in large part that's not a legal strategy so much as it is a public relations strategy to call attention to the fact that the agency is not consulting in good faith from the point of view of the tribe. As I mentioned, the agency must consider feasible mitigation measures, but in this case, this bullet means it must consider the feasible mitigation measures offered by the tribe. So For instance, if there is a sand quarry and the tribe has a sacred site that's going to be excavated, and the tribe has says, well, you can't excavate because that's going to destroy the sacred landscape. That puts the developer and the agency in an interesting position, because from the point of view of the project, that's not feasible because the project requires excavation. On the other hand, it is feasible from the point of view of the tribe because sand mines can be located anywhere. They don't have to be located in a sacred site. This is something that's going to be is playing out currently and will continue to be played out as long as this law is in effect. My argument as a tribal advocate is that the feasible mitigation measures tie in with the alternatives analysis, and if there's an alternative to digging sand in this particular place, then it's a feasible mitigation measure to go ahead and tell the private party that wants to do the excavation that they should do it elsewhere. Just because they happen to own this piece of property with a sacred site on it doesn't mean that that's the only feasible place to dig. Importantly, AB 52 confirms the confidentiality of tribal cultural resources information. So this is not just limited to sacred sites or archaeological artifacts or historical records or historical places. Like a lot of the other confidentiality provisions are, the only exception to this is if the information is already public. And then the enforceability, finally, which I promised at the beginning of the slide. Any mitigation measures that are agreed upon shall be fully enforceable. So, if you get to the point where there isn't an agreement, you can attack the CEQA document for not, for the agency not having done consultation in good faith, or you can seek to enforce the mitigation measures that have been agreed upon. But there is still significant wiggle room for an agency to end consultations, say that there isn't any meeting of the minds, therefore there wasn't a reasonable mitigation that was agreed upon, and so the mitigation they want gets put into place and is enforceable. And then the only option for the tribe is then to bring a suit or appeal it within the agency to say that the that the negotiations weren't in good faith. So, any questions about SB 18 or AB 52?
This legislation that you have in a few of these states, and especially here in California, does that include private property when there's discovery or there's known artifacts and there's known cultural sites and there's known sacred sites that are on private property? Does this apply to them, or is it just on state and federal lands?
No, it applies to private property so long as there is a permit or other state action that has to take place. So in the case of the sand mine hypothetical that I was talking about, that sand mine would be on private property, and it has to get a mining permit, surface mining permit from the county. And so the county has to go through CEQA because it's a county action. And then once the CEQA process is started, then the tribes that have informed the county that they want to be consulted with get consulted with. And then mitigation is hopefully agreed upon.
Well, I think that's pretty darn good, because I'm from Idaho, and anything on private property is hands off.
Right.
And the only time that a private property would be involved is if the tribes approach the private owners and indicated to them what's there. They already know anyway, and they probably notified the tribes of what's there. But a lot of times when we have to go to the private owners, there's usually it's just they want to know about it. We want to know about what they're going to do with it and things like that. But that's a conversation between us and the individual landowners.
Right.
And in some cases, not very often, but when the people retire and they're getting close to whatever, they donate their land to the tribes. And so that doesn't happen a lot, but when it does, it's a good thing. So if it's no problem, I'd like to get a copy of your presentation here to slap the state of Idaho around with it and see what they can do with it. Thank you.
I'm happy to help in any small way I can. If you want, you can either sign up or on the list down here, or give me your card afterwards. Okay. I'd be happy to email it out to anybody. So in both the case of SB 18 and AB 52, the definition of consultation meets several of the prongs of best practices for consultation. It's not the prior informed consent that we would look for under an international regime, and there are some good reasons for that. One of them is the way that the structures are set up, and that but basically it's because consultation isn't deemed to include consent in almost any case. I'll show you one exception to that, that in Washington State, but the legislation defines for both of those acts that it be timely and where feasible, seeking agreement. So it's basically right down the middle in terms of the type of consultation that we see in the United States. It doesn't guarantee any particular influence, but it does guarantee the ability to take part early, that you have a meaningful opportunity. I think, reading this, it doesn't ever say meaningful, but it does imply that, and when you read that in the context of the acts themselves, it certainly makes clear that the idea is that tribes could influence the outcome, and seeking agreement, which that's conditioned by the word where feasible, which is too bad. That wasn't necessary, I don't think, but seeking agreement is definitely positive. All right, before I move on to Washington, any other questions about California? Okay. So in Washington, the state has been moving toward a consultation, government-to-government relationship with the tribes in Washington for well over 20 years, so predating the official actions in the state of California by over a decade. The big ones are the Centennial Accord, which was the result of a summit between the state of Washington and all of the federally recognized tribes. It eventually resulted in a state legislative statement of the government-to-government relationship between tribes and the state of Washington. It also has led to inclusion in the Growth Management Act, which is a state law that governs comprehensive planning, general planning for counties and cities, which, like SB 18, the hook is that, it's when the local governments make plans for how their jurisdictions are going to be developed that a lot of sites are lost because they're not taken into account. The State Environmental Policy Act, which is Washington's version of CEQA. The Healthy Environment for All Act, which is also called the Environmental Justice Act. The Habitat Recovery Pilot Program, which is a funny little thing. And the Climate Commitment Act, which is is included in here because it has a very good model for consultation that Washington State and other states should look at in the future. I'll get to that in a minute, but It's not so much because climate is a particular tribal issue, which it is, of course, because tribes are bearing the brunt of climate change more so than most, but they also, because this included a very interesting period of state politics. So the Centennial Accord is sort of takes the place of the exhortation of like the state of California's executive orders, that there will be, each agency has to come up with a plan of accountability, which is an interesting turn of phrase rather than consultation. It sounds stronger. In effect, it wasn't. It didn't turn out to be as strong. And then 10 years later, in 1999, you get to developing a consultation process rather than an accountability process. And so the legislature enacted into law that there would be a government-to-government relationship with Indian tribes in the state of Washington. It's limited to federally recognized tribes. State agencies must collaborate, and this is a word that we'll see again soon. That's a word that the state of Washington likes in its statutes with regard to working with tribes, is to collaborate rather than consult. And I leave it to you to determine whether which one's preferable, collaborate or consultation. Collaborate tends to imply working together, whereas consultation is the more accepted term for the government-to-government communication and the government-to-government relationship. Unfortunately, it does say that program implementation must directly affect Indian tribes to be subject to the policies that agencies have to develop, and notably, going to my individualized best practice, that it has to be involving, where it involves a specific Indian tribe, you have to consult with that tribe. There's some procedural aspects. The tribal liaison reports directly to the head of the agencies, and then each agency produces an annual report to the governor on their consultation activities. So, within the Growth Management Act, which, as I mentioned, is important because that's where the local governments plan what land is going to be, more easily developed than other land, which land is going to be used for mining, which land is going to be used for housing, what's going to be preserved. It applies only to federally recognized tribes, and only those tribes whose reservation or ceded lands are in the jurisdiction of the local agency, whether it's a city or county that we're talking about. And in somewhat similar fashion to AB 52, the tribe has to take the first step. So in this case, the tribe actually has to not just take the first step, but also commit to a planning process that takes place in parallel with the not state process, but with the local government process. So the tribe gets to participate if it's also doing Growth Management Act type activities. So basically what happens then is that the local government and the tribe seek to come to agreement on an MOA, a Memorandum of Agreement. And if they can't, then the Department of Commerce steps in and tries to do some dispute resolution. And if that doesn't work, that's the end of the process. So it's a requirement to reach out. It's a requirement to try to collaborate, and that's it. In some cases, this has been successful. Several large tribes in Washington State have their own planning processes and do collaborate, but it's not what I would call enforceable. And then similarly to AB 52, but not as well, I'll leave it to you to determine whether it's as enforceable as AB 52. But the, state in policy. Sorry about that. Getting a little tongue-tied after a couple of days of talking. The State Environmental Policy Act, and it acts like CEQA. It's like CEQA in that it's more powerful than NEPA. Mitigations required if it's feasible, things like that. It also, unlike CEQA, explicitly gives the agency the substantive authority to not issue a permit based upon its environmental effects. CEQA, it has that, you as an agency can use that authority, but it's not as clear-cut as in Washington State. The goes through the same sort of thing: major actions, permits, building public facilities, and also adopting regulations and so forth. And those are the trigger. Then the agency determines whether it's significant, and then drafts an environmental document. And notably, unlike AB 52, AB 52 requires that the agency consult with the tribe prior to development of the document. In this case, it isn't required prior to development of the document. It's a good idea. And further limiting it, rather than talking about tribal cultural resources, it tends to focus on historic and archaeological resources. And it is tied into the NHPA consultation requirements that we talked about earlier. So as part of, and in California, if you've ever dealt with a project that's subject to CEQA, you'll be familiar with the checklist. Washington State has a similar checklist. The checklist has certain requirements that help you get through the process. And one of the requirements of the checklist is to describe the methods used to assess the potential impacts to cultural and historic resources on or near the project site. Options for doing that are consultation with tribes or with the Department of Archaeological and Historic Properties, or doing archaeological surveys, historic maps. I include all of these because just to make the point that consultation is encouraged but not explicitly required. In fact, the state agencies, local agencies tend to actually go ahead and consult with the tribes because for practical matters, it's a lot easier to consult than it is to face a lawsuit at the end of the process. Still, though, it's not required, and some agencies don't and seek to get around that by doing traditional studies of the site or consulting with other state agencies. Of course, the backup to this is that if there's federal involvement, it becomes a federal undertaking, and then NHPA applies, and then they have to consult through the federal agency. Now, just like with AB 52 and CEQA, mitigation is required if there are significant impacts and if the mitigation is feasible. So I've listed here what the guidelines say, the checklist says with regard to mitigation. Basically, you get down to, you have to get down to the end of the list to see that one of the mitigations that is suggested by the agencies is meeting tribal needs regarding the sanctity of a location. So it's still in the hands of the agency. It's not a negotiated process. It's they can consult with tribes, but they are not required to, and they are not required to then consult specifically on the mitigation. So significant difference between California and Washington on that regard. And then, interestingly enough, I threw this in because the Department of Archaeological and Historic Preservation is sort of the home of this concern within the CEPR process, and it refers to consultation specifically as arising in the Section 106 process. So a bit of a disconnect. The consultation is permitted and encouraged with tribes, but then defined only in terms of NHPA. Now we get to more recent acts from the last few years. The tribes have been successful in including larger degrees of consultation in state statutes. And in this case, this is the EJ Act, and the also called the Healthy Environment for All Act, or HEAL Act. And it aims to, the idea of the act is to incorporate environmental justice into all agency plans. In doing that, in incorporating environmental justice into agency plans, it requires that the agency consult with tribes. It only requires consultation pertaining to tribal lands, which is lands actually owned by tribes and their sacred sites, cultural properties, and burial grounds. So it's quite broad. It's not just the, even though it's called tribal lands, it expands out to include all of those other interests as well. The idea, well, I already talked about this, but the point is to develop the framework and in coordination with tribes. And I should have also mentioned that covered agencies are focused on those agencies that have significant environmental responsibilities. So the agencies that of ecology, health, natural resources that are responsible for regulating the environment, as well as commerce, agriculture, transportation, and the Puget Sounds Partnership, which are more of on the development side. And this is the first place where we see that the consultation needs to be independent of any public participation process required by state law. Obviously, with AB 52 and SB 18 in California, those are special consultation processes that are not available to the public, but this is the first time that we see it set out in state law explicitly that consultation doesn't just mean seeking public notice and comment on an action. It means actually talking to tribes, not just through public participation. And it also significantly puts the onus on the agency, also for one of the first times, to actually do the consultation regardless of if there's a request from the tribe. I'm going to skip over some of this stuff because getting into a lot of detail, and we're at about an hour, a little over an hour. But if you have any questions about the HEAL Act, feel free to raise your hand or talk to me afterwards. The Habitat Recovery Pilot Program is only in here because it's the only example I could find of where tribal consent is required for something. So in this case, if you do a habitat conservation recovery program in Washington State, basically for salmon, there are a lot of permits required, and there's a streamlined process that you can go through for a single permit instead. But if it if it affects a tribe, then the tribe can essentially withhold its consent to the streamlined process. That doesn't mean that the habitat restoration project can't go forward. It just means that it has to go forward through all the other hoops that it usually would have to go through. But this is the, so that is the only instance of consent that we're going to talk about, other than the international standard of prior informed consent. Now, the Climate Commitment Act is Washington State's version of our global warming law, the greenhouse gas law in California. It has, however, a lot of grants, billions of dollars worth of grants in it. And this was an interesting situation in state politics, because there was a consultation requirement in the original Climate Commitment Act, but because the governor of Washington has a line item veto, he line itemed the tribal consultation requirements, and because they were too aggressive and he thought would interfere with the act. In the end, what he ended up with the amendments was a much more robust requirement to consult with tribes. And in this act, there are both funding decisions and programs. So both of those are subject to tribal consultation. So as the agencies are deciding on how to spend the funds by giving them out as grants, they have to consult with tribes about those that affect tribes. They also have to consult with the tribes on their policy development of policy under the Climate Commitment Act, which means discussing with tribes things like the cap and trade program for greenhouse gases in Washington. The consultation requirements also flow down to the local government if the local government receives funding under the Climate Commitment Act. And there's a very interesting process here. So if an applicant, say an energy company that wants to do a project, applies for funding, it's going to have to go through a pre-application process where the applicant actually notifies the tribes of the location, scope, preliminary application details, etc., at the earliest possible date prior to submitting the application to the state agencies. It's all affected tribes within the project area. That means tribes with any sort of resource within the project area. The applicants must offer to discuss the project. Tribal comments become part of the official application file. So if a tribe dislikes the project or opposes it, then the applicant has to include those adverse comments along with its application, so the agency knows up front that the tribe is opposed to it. This is the first time I've seen this in writing. With regard to AB 52, often a private developer is left with the requirement to go ahead and get the feedback of the affected tribes, because they are also performing the environmental analysis and so forth. So it's up to the developer to do a lot of the negotiation with the tribe. That's not written into the law, but it's just as a practical matter is necessary. In the Climate Commitment Act, which may be the model for future consultation in Washington State, the applicant is required to do that up front. Now, this is practically a very good idea. In a doctrinal sense, it's not so great because it means that the state is fobbing off its responsibility to consult with tribes on private applicant. It retains that responsibility, but the meat of the issue is really going to be at the beginning of the process, and then the application, once the application is in, the agencies then must engage in early, meaningful, and individual consultation with federally recognized tribes that are affected by the action or may be affected by the action.
What would be the compelling action to force either the state or a state agency or other parties within a state when you have a state government that's probably not as progressive or is like literally breaking the other direction from the previous government? Mm-hmm. So what kind of enforcement mechanisms are in place for a failure to consult? I saw one of your one of your tabs in there that said a document is certified even after a failed consultation. I'm going to tell you that some of the states will consider a consultation with a tribe as a phone call that either doesn't get answered or they left a voicemail, and then they continue on with their process. So
Yep.
do you have any information as to, forced compliance or some kind of accountability?
I think that not to sound like a good government guy, but the thing to do is to try to get to the governor's office and to explain the need for collaboration, or whatever term you think is most acceptable to them, and point out the difficulties that come when tribes aren't included in decision-making processes, because it leads to litigation, it leads to bad press, and it leads to lack of a good relationship between the state and the tribes. Within legislatures too, it can be pointed out that, in particular over tribal cultural resources, that this is something that tribes aren't going to let go, and so it's something that's going to continually be something that's going to come up in litigation or in the press, and it's that collaboration or consultation is far better than fighting over this. I think that there are those who react immediately against the idea that there should be some what they term special dispensation for tribes, but most states have come around to the idea. Even Alaska has finally acknowledged that there are over 200 tribes and that they are governments within Alaska. So, most states have, accepted where, back in the, when I first started practicing in the 90s, there were still states that sort of viewed tribes as private associations, and there aren't, to my knowledge, there aren't any states that view them that way anymore. And if you can focus on the fact that the state government has, for instance, in general, state government has responsibilities to communicate with the counties and local and cities, and that tribes are in a position where they are governments, although they're not under the state. There are governments that also have jurisdiction within the bounds of the state, and so it only makes sense to to do actual consultation rather than just leaving a voicemail, or or in some cases not even that. There have been instances with federal agencies where the federal agency lost, for instance, for a solar project under the Recovery Act. It lost the case on the basis of consultation because it basically lied and said, we consulted, meaning they sent out letters to a bunch of different tribes, not to the tribe that was affected specifically, and didn't actually go and seek out their consultation. So in that, and I think that some of that is transferable to the state, even though you don't have the same hook, you don't have federal trust responsibility. There's still a relationship there that needs to be accepted, that tribes are not going away, and they're going to continue to be, if they're not friends, then they're going to be enemies, or at least I don't remember the phrase, but amicable adversaries. That and that's not that doesn't do the state any good either. So.
Okay. My name is Justin. How does the NAGPRA come into play?
How does what?
The Native American Graves Reparation Act come into play?
Oh, NAGPRA. NAGPRA requires that any institution receiving federal funds, consult with tribes to return culturally identifiable remains and associated funerary objects, and it is a federal requirement, and it is then it passes down to the recipients of federal funds. California NAGPRA is more aggressive and doesn't depend upon federal funding. And also doesn't have as big a loophole for culturally unidentifiable remains. So that's, in some cases, the institutions that hold ancestors' remains are state funded, are part of the state. So in the case of the University of California, for instance, in my hometown, Berkeley, it holds 10,000 people in its archives, and is being very slow after some 30 some odd years, is still resisting returning remains. So that's certainly a black eye for the state of California that the state has tried to address by doing its own Repatriation Act, and by the various state agencies have admonished the University of California for its behavior, and the legislature as well. So I don't know if that answers your question, but that's passes on, the federal consultation requirement passes on to state and private parties that way.
Yeah, that answers my question. Thanks.
Okay, thanks.
Hi, good morning. My name is Christine Herman. I work for the U.S. Forest Service, Chippewa National Forest in Minnesota, and tribal relations. And so I have a question about Washington State's HEAL Act. The language you shared with us said that consultation with the tribes was to be independent of any community kind of outreach consultation. And I'm wondering if, and assuming, and hope I'm assuming correctly, that that is prior to and not concurrent with, and that any input that the tribe offers to a decision is considered, and when possible made part of the plan that is then shared with the public?
Yeah, well, I don't know. I don't believe from my reading of the act or from the way that the agencies are implementing it that it has to be ahead of time. I think that the deadlines are so short in the EJ Act that I think that they're just doing it all at once. It just seems to be the way they're doing it. And I don't think that, I think that the tribal comments as well as the public comments will be added to the plans, and then that will be what everybody sees. So no, I don't think it's quite perfect. I don't think it's even close to perfect, but it is it's a big step forward. So, thanks.
Thank you.
Great.
So our tribe recently developed a tribal consultation policy that might not be in alignment or the same as the other agencies. Mm-hmm. So what happens if an agency has a tribal consultation policy but the tribe has their own? What takes precedence or jurisdiction?
Well, unfortunately, it would be the agencies, but I'm really glad you brought that up, because that's one of the things that I was going to add to this presentation and was afraid I didn't have enough time. Turns out I did. But I highly recommend that tribes adopt their own consultation policies, because currently tribes are being inundated with so many requests, particularly in states like Washington and California. They're being inundated with requests from the feds and from the state, local governments, and it's hard to determine what is most important. It's hard to, it takes a lot of staff time to figure out, which one to respond to, which one is going to be one that you take a significant amount of time to be part of. And a tribal consultation policy can address some of those things by letting a state know. And the state of Washington actually has put on websites the consultation policies for 3 different tribes. I don't remember the tribes except Grand Ronde, which is not in Washington, but has, I believe, usual and accustomed places in Washington State, and so it has interests there. And if the state agency is, in a lot of cases, I think that state agency employees, if they know that there's a protocol that the tribe wants them to follow, rather than simply sending a blind letter, they should follow the tribal protocol. I don't know how often that would actually work out, but most people are of fairly good faith, and I think that they, it would happen more often than not if it was a reasonable, consultation policy that it, also took account of the fact that state agency workers and local agency workers are going to be overwhelmed as well. So, but yes, I highly commend tribes that do their own consultation policies. It helps people know how to consult with them and sets expectations. Thanks.
On several of your, well, not several, but some of the states that you mentioned up here, they have tribal cultural properties.
Yeah.
Are those designated, or are they just said that's a cultural property place there? And do they happen, and I think my answer was, I mean, not my answer, but my question earlier was about state lands, federal lands, and private properties. Does, when a tribe asks for a section or a place to be considered a tribal cultural property, is that a hard thing to get done, or is it kind of just everybody agrees yes it is, or no it ain't, or how do the states that you mentioned here handle such a request about a tribal cultural properties being designated in an area?
Thank you, sir. I would respond in two different ways. One is that the states have processes similar to the federal government's in designating historic properties, and tribes often do not want to follow that because it then makes public to the world, that here's something that tribe takes seriously, that it's vital to the tribe, and then it invites, bad behavior. As far as under these acts, the tribe gets to decide what a tribal cultural property is, what a tribal cultural resource is under AB 52 in California. In Washington State, the tribal lands definition in several of these statutes that I whipped through talks about sites, sacred sites, and cultural sites. And it's up to, as part of the consultation process, the tribe identifies those things. And in both Washington and in California, best efforts are made to keep that information confidential. So there have been situations in California where a state agency or a local agency has said, we don't really buy that this whole landscape is sacred to you, or things like that, ignorant things like that, but it's not common.
I take it a little bit that there is some prohibition for the general public going out there then? Is the land sealed off from others?
No, that would have to be under some other authority. So, for instance, with a sacred site that's subject to consultation under SB 18, one of the possible mitigation actions would be to seal up the site, make it inaccessible, things like that. But it doesn't automatically happen. There has to be an authority under state law that allows you to do that. So in California, that would be, SB 18 is one of those.
Okay. Just out of curiosity, how many sites have been designated as TCPs?
No idea. Yeah.
No idea.
No, I mean, there have been.
Is it all on one hand, or do you need several hands to
There
count?
have been hundreds of consultations, and all of them would have involved, all or nearly all of them would have involved some sort of tribal cultural property.
Okay. But how many have been, well, I guess you kind of answered a little
How many
bit.
have been protected?
How many have been designated as tribal cultural properties?
Well, it's a transactional. It takes place during the consultation, and it's for the purposes of that project.
Yeah.
So
I kind of know all that, just want numbers.
Okay.
Thank you.
Sure. Next time, I'll figure that out.
You mentioned that you have represented tribes in consultations. Is there one golden tidbit that you can share? For example, if a tribe is requesting an alternative or mitigation that you would suggest as a practitioner to consider as a tip of the trade. So, one thing that maybe I could conceive of is if there's a construction project, you might want to have somebody who, a contracted consultant who really understands construction to present those alternatives. Are there any other things like that you've kind of learned to do?
Yeah, sorry for interrupting. What I was going to say is actually fairly similar to what you suggested, which is that to put yourself in the shoes of the state or local agency and the private applicant, not because their point of view is any more valid than the tribe's, but because in reaching a negotiated settlement, it's important to understand the person across the table from you and their motivations. And the other thing is to not be afraid of asking for exactly what you want. So if you want a sacred site to be protected, fenced off, or to be, or for there to be, well, I mean, this is actually pretty standard stuff to have a cultural resources monitor there. That's pretty standard. But if you want to shoot for something, if the tribe should ask for exactly what it wants, but also be cognizant of what your counterparty is, what their point of view is, so that you understand what makes them tick. Basic negotiation issues. But don't be afraid to ask for what you want.
I'm curious what your thought process is on with tribes who have a multi-state ancestral homeland and then projects that are in multi-state. So I'm from Montana. We have projects like a transmission line that goes from Montana to North Dakota. Montana has MIPA, North Dakota doesn't. So what are you thinking when it comes to consultation, dealing with the multiple tribes that have different cultural resource protection ordinances, and then the states that have different laws that pertain to cultural resource protection, whichever? I've asked one time if a multitude of laws or even just preservation ordinances can be put into a PA, and it's like none of the agencies could answer that question. So I was curious if you came across something like that where it's a multi-state, or multiple tribes that are on a federal project.
On a federal project? Okay. Well, I would take the point of view that you should look for the softest underbelly, so to speak, with the various state acts. So if Montana has a hook that you can use that. With the feds, though, that you have the opportunity then, if there are historic resources, to hook in all of the area and to require consultation on the whole thing, regardless of which state it's in. It would make sense, if this is a multi-state project, if the states are already talking to each other, which they ought to be, then it makes sense for them to then include the tribe in those conversations, at least with regard to tribal impacts. And that's what I would shoot for. I don't know that states, I don't know the character of the administrations in North Dakota and Montana. I know they're a lot different from California, but if there were a possibility to work that way. I don't know about a programmatic agreement that would involve all of them. I don't see any barrier to that. A three-way or four-way agreement between the tribe, the feds, and the two states to agree on how to treat tribal resources would seem to make a lot of sense. So I'm sorry if that hasn't been successful so far. Okay. Anybody else? Okay, well, thank you very much for your time.